Welcome to another deep dive. Today we're getting into a topic that looks simple on the surface, but, well, it gets complicated fast. We're talking about Bill B-5.
Right.
Now, you probably hear that and think, okay, one bill. But here's the thing. There isn't just one significant Bill C-5 in recent Canadian history. There are actually two.
Yeah, two completely separate ones, different times, totally different goals. It's definitely caused some confusion out there.
Exactly. So that's what we're here for today, to kind of untangle that confusion for you.
So the first one we should probably talk about is the older one. That was all about the criminal justice system, things like mandatory minimum penalties, conditional sentences. It first popped up around December 2021, but the ideas were actually in an identical bill back in February 2022.
Okay, so justice reform. And the second one?
The second Bill C-5 is, well, much newer. It just passed June 2025 under Prime Minister Mark Carney. It's officially called the One Canadian Economy Act, or sometimes the Building Canada Act. And it's about something totally different, speeding up major economic projects, inter-provincial trade, labor mobility, big picture stuff.
Got it. Two C-5s, two very different worlds. So our mission today is pretty clear. Unpack both of them. Look at what they were trying to do, the debates they kicked up, what actually happened.
Yeah, give you the full picture, name confusion aside.
Okay, so let's unpack this. Starting with that earlier one, the Criminal Justice Bill C-5. What were the core problems it was really trying to get at?
Well, the sources really point to some deep systemic issues, overrepresentation, disparities, particularly for Indigenous and Black offenders. They face way more hurdles getting back into society safely.
Hurdles like what specifically?
A big one was how prisoners got classified for security levels. There's this tool, the custody rating scale, but staff could, and often did, override it.
And that led to?
It led to Indigenous and Black offenders being disproportionately stuck in maximum security. The numbers are pretty stark, actually. They were placed at higher security levels on admission at twice the average.
Twice the rate. Wow.
Yeah. And Indigenous and Black men ended up making up 51%, over half of maximum security placements. For Indigenous women, it was even more extreme, placed in max security at more than 3 times the rate of non-Indigenous women. They made up almost 70% of women in maximum security.
70%. That's staggering.
It is. And the sources also mention gaps, like not enough correctional officers or program staff who reflected the populations in certain institutions, especially those with many Black offenders, and gender gaps at women's facilities, too.
So it sounds like the system itself, maybe unintentionally, was sort of trapping people, especially from certain communities. Is that fair to say?
That's exactly the picture the sources paint. It wasn't just about individuals, but how the mechanisms, classifications, sentencing were kind of hardwired to produce these unequal outcomes. And a huge piece of that puzzle was mandatory minimum penalties, MMPs.
Okay, MMPs, how do they play into this? How do they make things worse?
Well, Canada has a lot of them, 67 in the criminal code, another 6 for drug offenses.
Yeah.
And the evidence showed they hit Indigenous, Black, and marginalized communities hardest. They just didn't allow judges any flexibility.
Right, took away discretion.
Exactly. So this Bill C-5 proposed getting rid of MMPs for drug offenses, tobacco stuff, and 13 specific firearm offenses, things like using a gun during a crime, having an unauthorized weapon, some trafficking.
But not all firearm offenses.
No, and that's key. It explicitly kept MMPs for more serious gun crimes, like with restricted or prohibited firearms or anything linked to organized crime. The whole point was to give judges back that discretion. Let them look at the person, the situation, use jail only when necessary.
And this connects to the Gladue principle, right?
Absolutely. The Gladue principle requires courts to consider the unique background factors of Indigenous offenders. Colonialism, residential schools, systemic discrimination, and look for alternatives to jail. Repealing these MMPs was seen as crucial to actually letting judges apply Gladue properly.
Okay, that makes sense. So less reliance on mandatory minimums. What about the other big piece? Conditional sentencing orders, CSOs. What are they, and why push for more of them?
So a CSO lets someone serve a jail sentence of less than 2 years out in the community, but under really strict rules like house arrest, curfews, treatment programs, no weapons. It has to be safe for the public, obviously.
Like a middle ground between prison and full release?
Kind of, yeah. Before a lot of MMPs came in, Canada used CSOs quite a bit, over 11,000 cases, but that number had dropped to around 6,000. This Bill C-5 wanted to make them available again for maybe 5,000 people who weren't seen as a public safety risk. Let them stay connected, keep jobs, maybe.
But not for serious crimes.
Definitely not. The bill was clear. No CSOs for things like advocating genocide, torture, attempted murder, offenses that still had MMPs, or serious terrorism or organized crime stuff. It was aimed at lower-level offenses where community supervision made sense.
Seems like a careful balance they were trying to strike.
It was. And related to that was the approach to simple drug possession.
Ah, yes, the public health angle. What was the proposal there?
The idea was to require police and prosecutors to actually consider alternatives before laying criminal charges for simple possession. Treat addiction more like a health issue, less like a crime.
So divert people away from the courts.
Pretty much. Use the discretion police already have, direct people to treatment or support programs instead of slapping them with a criminal record. It wouldn't interfere with prosecutors' discretion in places like Quebec, where they already have that pre-charge power. And there was also a part that would let simple possession convictions be kept separate after 2 years, sort of like sealing the record if they stay out of trouble.
Beyond the legal nuts and bolts, did the sources talk about the human side? Like personal stories that showed why this was needed?
Oh, absolutely. Those were powerful. There was one Liberal MP, he used to run a youth center for Tamil Canadians, worked with kids caught up in the system.
Right.
He said, locking someone up, that's the easy part. The hard part is helping them turn things around, reintegrate. He saw that giving support, offering off-ramps, actually worked. Kids became contributing members of society.
Makes sense.
Yeah.
The harder path often yields better results.
Yeah. And another MP from Scarborough Rouge Park in Ontario, a very diverse area, a large Black community, he talked about hearing constantly from constituents about over-policing, over-incarceration, the trauma it caused. Yeah. These weren't just statistics. They were real people, real communities being harmed.
It really brings it home.
Right.
So given all this, the stats, the stories, the proposed changes, how did the legal community react? Was it mostly supportive?
Overwhelmingly, yes. Legal experts, academics, bar associations, the Canadian Bar Association, South Asian Bar Association, African Nova Scotian Justice Institute, criminal lawyers, they were largely on board. They'd been arguing against MMPs and for CSOs for years.
They saw it as overdue.
Pretty much. A necessary correction. Even victims groups, while maybe having mixed feelings on some specifics, generally acknowledge that a fairer system that reduces reoffending benefits everyone in the long run.
Okay, a clear picture of the first Bill C-5. Now, let's completely shift gears. The other Bill C-5, the recent one, the economic one. This sounds like a whole different beast.
Oh, it absolutely is. June 2025, the One Canadian Economy Act, or Building Canada Act. It's been called a landmark nation-building bill, and it gives the federal government some pretty extraordinary new powers.
Nation building. Why now? What's the big push?
Two main drivers, really. First, responding to trade pressures, especially from the U.S. tariffs, protectionism. Second, a really strong push from the Carney government to boost the Canadian economy. The stated goal is ambitious: to make Canada the strongest economy in the G7.
Strongest in the G7, okay.
Yeah, and Carney even invoked the St. Lawrence Seaway, built in 5 years back in the day, as sort of a "we used to build big things fast, let's do it again" kind of message. And it's not just federal. BC and Ontario have passed similar provincial laws to fast-track projects, too.
Interesting. So there's a wider trend. What are the core components of this federal Bill C-5 then? You mentioned two parts.
Right. Part one is the Free Trade and Labor Mobility in Canada Act. Pretty much what it sounds like. It aims to knock down barriers to trade within Canada, goods, services, and make it easier for workers to move and have their credentials recognized across provinces.
Can you give an example of a barrier it targets?
Sure. Think of, like, a farmer in Saskatchewan trying to sell organic vegetables in Alberta, but facing different certification rules. Or a welder from Nova Scotia needing to get recertified just to work on a federal project next door in Newfoundland. Or an Ontario tech company with an energy-efficient gadget facing hurdles selling it in BC. This part tries to smooth all that out.
Removing internal friction.
Exactly. And like I said, a bunch of provinces were already moving this way anyway. PEI, Nova Scotia, New Brunswick, Ontario, Saskatchewan, Manitoba had laws. BC and Quebec were working on theirs, so there was momentum.
Okay, that's part one. What about part two? The Building Canada Act.
This is where the big powers come in. It's focused on accelerating what they call national interest projects.
And what qualifies as national interest?
There's criteria. The project has to strengthen Canada's autonomy or security, provide economic benefits, be likely to succeed, advance Indigenous interests, that one's controversial, we'll get to it, and help with clean growth or climate goals.
Okay. And how does it accelerate them?
This is the core of it. It creates a streamlined approval process. Projects deemed national interest can essentially bypass parts of existing federal laws, like the big one, the Impact Assessment Act.
Bypass environmental assessment?
Well, bypass provisions of it is the language. It sets up a new federal major projects office, a single window for companies proposing projects. The goal is one project, one assessment, aiming to cut government review times in half.
One assessment instead of multiple hoops.
That's the idea. And the relevant minister gets a powerful tool. They can issue a single document that is basically all the required federal permits and authorizations rolled into one, something that could normally take years.
Wow, that is a lot of power in one place.
It is. There are some checks, and annual independent review of projects is required, and the master permit expires if the project doesn't substantially start within 5 years. But yeah, it's a major consolidation of authority.
So, given these sweeping changes, who was backing this? Who thought this was a good idea?
Well, proponents, business groups, industry associations, the government itself obviously argued it was essential for economic growth, create jobs, and they did add an amendment stressing the importance of unionized jobs. That's worth noting.
Okay.
Strengthen supply chains, energy security, make things more affordable. The big frame was cutting red tape and duplication that they argued was holding Canada back.
Getting things built.
Exactly. Sending a message to investors, too, that Canada means business, that projects won't get bogged down forever. You heard quotes like the Chamber of Commerce saying, now is the time for bold action, and the Natural Resources Minister saying Canada needs delivery, not delay.
A clear message. But, like you said, extraordinary powers bypassing normal processes. There must have been significant opposition.
Oh, absolutely. Huge pushback. On several fronts. First, the process itself. Critics like the NDP, the Canadian Centre for Policy Alternatives, they called it a parliamentary power grab.
Strong language.
Yeah, accusations of ramming it through, bypassing debate. One critic even said it was like Stephen Harper all over again, but on steroids, suggesting it was an overreach without a real emergency to justify it.
Okay, process concerns. What else?
Indigenous rights were a massive flashpoint. Remember that criterion about advancing Indigenous interests? Many Indigenous leaders didn't buy it.
Why not?
Big concerns that the 2-year timeline for decisions wouldn't allow for proper consultation. The demand was for free, prior, and informed consent, or FPIC.
Can you explain FPIC quickly?
Sure. It's basically the right recognized internationally for Indigenous peoples to give or withhold consent to projects affecting their lands and rights. It's about self-determination, not just being consulted after decisions are made.
So they felt this bill undermined that.
Deeply. Senator Paul Prosper, whose Mi'kmaq called C-5 not reconciliation but a betrayal of it, his office even got racist threats for his opposition, which is just appalling. The Assembly of First Nations flat out said the law was out of step with federal law on Indigenous rights.
That's incredibly serious. What about environmental groups?
They were very worried, too. Groups like Equiterre pointed to vague language, the bypassing of environmental laws, less accountability, too much power in one minister's hands, fears about unchecked development, growth without borders.
And was there debate about whether this was even necessary? Did Canada really need such drastic measures?
Yeah, that came up too. Was there really an emergency? Some argued red tape is often a scapegoat. Real delays often come from economics, like low commodity prices, not just regulation.
Right, like that LNG project you mentioned earlier.
Exactly. LNG Canada in Kitimat, fully permitted, but the company hasn't pulled the trigger on the final investment. Shows regulation isn't always the main hurdle. Plus, there were worries about stepping on provincial toes, especially in Quebec regarding energy projects. And even unions weren't united. Some supported it, but a major Quebec federation, the CSN, reportedly did not.
So a real mix of support and very strong opposition across different sectors.
Definitely a contentious piece of legislation.
So what does this all mean? Pulling it together, we've got these two Bill C-5s. One, trying to fix deep systemic issues in criminal justice focused on individuals and communities.
Right, dealing with overrepresentation, judicial discretion, rehabilitation.
And the other, a huge economic play focused on national infrastructure, trade, speed, and efficiency.
Yeah, tackling perceived barriers to growth, centralizing power to get big projects moving faster. It really shows how one label can cover such drastically different legislative worlds.
It really does. And despite being so different, they both touch on these core Canadian tensions, don't they?
Absolutely. That balancing act between efficiency and rights, between economic growth and social equity, between national goals and the concerns of regions, communities, and especially Indigenous peoples, These bills just throw those tensions into really sharp relief.
So for you listening, maybe the question to ponder is this. How much of what gets called red tape is genuinely just obstruction, a red wall stopping progress, and how much is actually vital? Due process, protecting communities, the environment, basic rights?
It's that fundamental question of balance. Where do you draw the line?
Exactly. It's a delicate balance, and these two very different bills, C-5, really force us to think about where Canada stands and where it's headed on that tightrope.